She then proceeds to pick up that paving brick, the solar light, and throw them at Ms. Mossholder. Ms. Mossholder could always say, well, yeah, she hurt me and therefore it's an assault. No, she didn't claim that. They hit her, but she wasn't hurt. She didn't claim injury. She didn't tell the officer. She claimed injury. Criminal damaging, and the court is the final instructor of law. He will tell you what all of the elements are. But criminal damaging in a nutshell is knowingly the venue. Where did this happen? Identification. Did the defendant create a substantial risk to property that doesn't belong to her? So what happened to that light? It broke. It's criminal damaging. What happened to the fence? That's criminal damaging. As Ms. Mossholder said, it's not the defendant's fence, that little section. Criminal mischief, knowingly move or tamper with property of another. She doesn't own that paving tile. She doesn't own that solar lamp. She doesn't own that fence. That's moving or improperly tampering with someone else's property. Menacing, causing another to believe that they would cause them physical harm. I don't have to prove she caused her physical harm, that she caused her to believe. I believe, at least during the testimony of Ms. Mossholder, you can sense she does not like and is afraid of the defendant. When you're threatened to, I'll kick your ass, I'll kill you, and the various other threats, is it so unreasonable to believe that someone's going to get afraid that they would be harmed? And finally, based upon the evidence that you've heard, disorderly conduct, recklessly, the judge will define that term, cause inconvenience, annoyance, or alarm by fighting, threatening harm to persons or property, or in violent or turbulent behavior. Isn't that exactly what the defendant did? Did she persist? Ms. Mossholder told her to stop several times. Get out of here. Stop. Nope. Kept right on going. It was only when the police were called that the defendant took off and could not be located. And it's not just Ms. Mossholder's word. Well, she doesn't like her. She'll make things up and all that. We have Cassandra Dyer, the hearing impaired lady you heard of, or heard about and heard from. You had the opportunity to see her, listen to her, judge her credibility.
The state says she stormed the porch, hurled threats, and left damage behind. The defense says it's a one-sided story built on bias, gaps, and doubt. In this courtroom, it's not about drama. It's about what you can prove.
The judge will tell you how to do that. Was she lying? Did she come in here and lie, just to lie? Well, she has hearing impairment. She had her hearing aids on that day. Where is her video? What she's trying to describe is the way it's set up, it doesn't really catch except for an alley. Whatever happened did not happen in the alley. It might prove that the defendant was there, but I don't think there's any reason to doubt that the defendant was not there. Well, what about the audio? Who says she had the audio on? Who said that? No one from that stand. This was loud enough, with her windows open and her hearing aids in, the commotion that occurred down at that other residence, the Mossholder residence. This witness walked outside, walked towards the residence, identified the defendant as being there, heard the threats, and saw the objects being thrown. I can go on and on, but I'm not going to bore you. You've heard the evidence. It is what it is. Just be patient. Listen to counsel's argument. I'll have one last chance because it is my burden of proof. And then listen carefully to the judge's instructions. I do resent any fact that I've somehow cherry-picked or withhold evidence because I didn't. Obviously, defense has the videos. The officers are here. He could have played them if he wanted to, rather than just impeach or try to impeach witnesses. But I would submit to you that using your reason and common sense, applying the law to the facts that you heard, the defendant is in fact guilty of each and every one of these. Thank you.
Thank you. Mr. Bodike?
The judge will soon instruct you that proof beyond reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon in the most important of his or her affairs. Now, oftentimes we use that as an analogy for a doctor's appointment, right? The doctor says you have cancer or a serious illness. Did he prove enough to where you wouldn't want a second opinion? So, has the state provided, by those two witnesses, enough evidence that you wouldn't say, maybe I should get a second opinion. Maybe I want more testimony, more evidence in this case. So, to rebut some of the things, let's get into what we did here. We heard from two witnesses. From Ms. Mossholder, who told you that she wasn't quite sure actually. Did she move in the day after that Cindy Lemon was evicted? Did she move in 2 weeks after? Was she evicted? Did she leave on her own behalf? She said two different things. She said first she left on her own behalf. She wrote down she was evicted. You also heard her say that she tried not to get into the middle between two married couples, and yet she was calling up the landlord or the property owners of the abandoned places that Miss Levin was staying at. They've been married for 20 years. 20 years. And this man just abandons her, kicks her out.
Objection, Your Honor, that's not.
That is, in fact, not in evidence, so I'll sustain the objection.
You heard her say the reason there was no divorce was over money. Cindy has been a stay-at-home wife for the last 20 years. She has no money. How would she have been afraid when she had a baseball bat and a pit bull next to her? And the prosecutor says that that's not an attack dog. A pit bull isn't an attack dog. And she said she had text messages earlier from that day showing that could have proved her threatening to show up that day. We didn't produce any of those. The prosecutor didn't call the officer who could have recorded all of this stuff, could have got the text messages, could have went around, could have gotten doorbell cameras, didn't put her on the stand whatsoever. We did hear that she gave her lots of compliments, that she was calling, they were continuously calling officers. She's alleging that no other officer would pick this case up because they were still married. You also heard that she refers to them as brothers and sisters, but also roommate, but also calls them babies sometimes. You heard from the other witness, Miss Cassandra Dyer, who is hearing impaired, who had a claim that she had a video of her there that day, but never produced it, that it has recording on it. She claimed sometimes it's not on. Is it reasonable to think somebody has a doorbell camera, that they go on there and they decide when they turn the audio on and when they turn the audio off? Is it that, do you think she was that sophisticated or had a reason to turn that on and off at any given point? Never produced that. You never produced the husband. He was on the list. They could have called him. I know we try to claim that I can call him too. I can't cross-examine them. If I call them on the stand, they can say whatever they want. I can't rebut any prior statements. I can't do any of that. Only he can bring them on to allow me to cross-examine them. You know, unfortunately, we didn't have an opportunity to talk to her husband on this case. The city is 90 pounds soaking wet. She had a baseball bat and a pit bull next to her. Do you really think she was afraid? Even if this is true. And as of now, you have not enough proof, not beyond reasonable doubt, not something that I would argue you could rely on to make a serious medical decision on this. You have two witnesses. One could be very biased. She just moved in. She's living with her husband. She still hasn't gotten divorced. It's been a year and a half. She's homeless, has no money. Yet they call the cops on her. Yet they, if Sydney is locked up, certainly can't get a divorce then. She's custody of the state. Wouldn't have to pay her a dime. And this is the case. You're all here on the taxpayer's dime. Proof that she showed up and did this that day.
Thank you, Mr. Bodek. Mr. King, you may begin your proceed with your rebuttal argument.
Thank you. Don't quite know what the heck that means. You're on the taxpayer's dime. Every juror that's ever called that gets paid to be here, whether you serve or not, is on the taxpayer's dime. I'm on the taxpayer's dime. The judge is on the taxpayer's dime. What does that have to do with anything? Congratulations, defense counsel. You talked about everything except the actual facts. What difference does it make to the state's case when Ms. Mossholder moved in, whether the defendant was evicted or not? She had no right to be there. Why was she there? Text messages. They were to Mr. Lutman, not to Ms. Mossholder. What did that have to do with what the defendant did with Ms. Mossholder? They weren't threats to her, they were threats to Mr. Lutman. Defense counsel makes certain statements. Well, he couldn't call Mr. Lutman or the officers. Yes, he can. They're here. They're on the other side. They've been identified. Not to give you a legal crash course, but they could even be called as on cross-examination, and no, he isn't stuck with their answer. He makes assumptions about, well, the ring camera, the bell camera. Who says it was that as opposed to a video? Well, how can you be afraid if you have a Rottweiler and a ball bat? What if someone's standing off your porch throwing a solar light at you? Going to be scared? Going to think they might hurt you? What if they pick up a paving tile and heave it at you? No cause for concern? Is it so unreasonable? Ladies and gentlemen, you've heard the evidence. Soon the judge will instruct you on the law and it'll be in your hands. But again, I want to thank you for your attention and cooperation. Thank you.
Well, ladies and gentlemen of the jury, you've heard the evidence and the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or to apply your own conception of what the law should be. You'll be provided with written copies of these instructions to have you with you during your deliberations, so please don't concern yourself with trying to memorize what I'm telling you now. A criminal case begins with the filing of a complaint. A complaint informs the defendant that she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts at issue all the essential elements of the offenses. The defendant is presumed innocent until her guilt is established beyond a reasonable doubt. The defendant must be found not guilty unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the complaint. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses and the exhibits that were introduced during the trial. Evidence may be direct, circumstantial, or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. This includes any exhibits admitted into evidence during the trial. Circumstantial evidence is proof of facts the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of humankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of fact which you may, but are not required to make, from other facts which you find have been established by direct evidence. Whether or not an inference is made rests entirely with you. Direct and circumstantial evidence are of equal weight. The evidence does not include the complaint, any opening statements, including closing arguments of counsel. The opening statements and closing arguments are designed to assist you. They are not evidence. Answers of witnesses and statements of counsel that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to such a question may have been. You must draw no inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity that he or she had to see, hear, and know the things testified to, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because she was placed under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not. It is not necessary that the defendant take the witness stand in her own defense. She has a constitutional right not to testify. The fact that she did not testify must not be considered by you for any purpose in determining whether the state has proven its case beyond a reasonable doubt. There are 4 separate counts. I'm going to start reading those to you now. The defendant is charged in count 1 with criminal damaging. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 31st day of July, 2025, in the city of Newark and in Lincoln County, Ohio, the defendant knowingly, by any means, caused or created a substantial risk of physical harm to the property of another without the other person's consent. You've heard a lot of talk about essential elements. I'm going to define those for you now. Knowingly. A person acts knowingly, regardless of her purpose, when she is aware that her conduct will probably cause a certain result, or she is aware that her conduct will be of a certain nature. A person has knowledge of circumstances when she is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of the facts and that her acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that her conduct would probably be of a certain nature or cause a certain result. Cause. The state charges that the act or failure to act of the defendant caused physical harm to property. Cause is an essential element of the offense. Cause is an act or failure to act which, in a natural and continuous sequence, directly produces the physical harm to property, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. Substantial risk. Substantial risk means a strong possibility, as contrasted with the remote or even a significant possibility, that a certain result may occur or that certain circumstances may exist. Physical harm to property. Physical harm to property means any tangible damage to property which, in any degree, results in a loss of its value or interferes with its use or enjoyment. Physical harm to property does not include wear and tear occasioned by normal use. Property. Property means any property, real or personal, tangible or intangible, and any interest or license in such property. In count 2, the defendant is charged with criminal mischief. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 31st day of July, 2025, in the city of Newark and in Lincoln County, Ohio, the defendant, without privilege to do so, knowingly moved, defaced, damaged, destroyed, or improperly tampered with the property of another. Privilege. Privilege means immunity, license, or right conferred by law or bestowed by express or implied grant arising out of status, position, office, or relationship, or growing out of necessity. Knowingly is also an essential element of this offense. However, I've already defined that for you and I will not read it again. Tamper. Tamper means to alter improperly, to meddle with, or to disturb physically. Property is also an essential element of this offense, but I've already defined that for you and I won't read it again. In count 3, the defendant is charged with menacing. Before you can find the defendant guilty of menacing, you must find beyond a reasonable doubt that on or about the 31st day of July, 2025, in the city of Newark and in Lincoln County, Ohio, the defendant knowingly caused Kathy Mossholder to believe that the defendant would cause physical harm to her. Knowingly is an essential element of this offense. Once again, I've already read that for you, but the definition will be included. Cause is a little bit different here. The state charges that the act or failure to act of the defendant caused Kathy Mossholder to believe that the defendant would inflict physical harm. Cause is an essential element of this offense. Cause is an act or failure to act which, in a natural and continuing sequence, directly produces the belief that the defendant would inflict physical harm. The second paragraph of cause is identical to the first time that I read you that definition. Physical harm to persons. Physical harm to persons means any injury, illness, or other physiological impairment regardless of its gravity or duration. In count 4, the defendant is charged with disorderly conduct. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 31st day of July, 2025, in the city of Newark and in Lincoln County, Ohio, the defendant recklessly caused inconvenience, annoyance, or alarm to another by engaging in fighting, threatening harm to persons or property, or in violent or turbulent behavior, and did not cease after a reasonable request to do so. By the way, in your jury instructions, there's a typo. The date is wrong on count 4, but all these counts are alleged to have occurred on July the 31st of this year. Recklessly. A person acts recklessly when, with heedless indifference to the consequences, she disregards a substantial and unjustifiable risk that her conduct is likely to cause a certain result or be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, she disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Cause. Again, cause is a little bit different here. The state charges that the act or failure to act of the defendant caused inconvenience, annoyance, or alarm to another. Cause is an essential element of this offense. Cause is an act or failure to act which, in a natural and continuous sequence, directly produces the inconvenience, annoyance, or alarm. There's also the second paragraph which I've already read to you. Physical harm to persons is an essential element of this offense. I've already read that to you, and I will not do so again. If you find the defendant guilty of disorderly conduct, it is your duty to deliberate further and to decide if the defendant did not cease her behavior after a reasonable request to do so. If you find the defendant not guilty of disorderly conduct, you will not consider if the defendant failed to cease her behavior after a reasonable request to do so. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or all of the offenses charged in the separate complaints, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or all of the offenses charged in the separate complaints, your verdict must be not guilty as to such offense or offenses according to your findings. Consider the charges separately. The charges set forth in each complaint constitute a separate and distinct matter. You must consider each charge and the evidence applicable to each charge separately, and you must make your findings as to each charge uninfluenced by your verdict as to the other charges. The defendant may be found guilty or not guilty of any one or all of the offenses charged. Your initial conduct upon entering the jury room is a matter of importance. The first thing you should do is to elect a foreperson by a simple majority vote. The foreperson will see to it that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as every other juror. It is not wise to immediately express a determination to insist upon a certain verdict because if your sense of pride is aroused, you may hesitate to change your position even if you later decide that you are wrong. Consult one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your own individual judgment. Each of you must decide this case for yourself, but you shall do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest beliefs in order to be congenial or to reach a verdict solely because of the opinion of other jurors. You may not discuss or consider the subject of punishment. In the event you return a verdict of guilty on any of the charges, the duty to determine the punishment is placed by law on the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdicts accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality, and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their cases were fairly and impartially tried. If during the course of the trial the court said or did anything you consider an indication of the court's view on the facts, you are specifically instructed to disregard it. If during your deliberations you have a question for the court, it should be discussed in the privacy of the jury room. Your question or questions should be reduced to writing so that there will be no misunderstanding as to what you request. It should not reflect the status of your deliberations. It should then be delivered to the bailiff by ringing the bell, and she will submit it to the court. If the court can answer your question, you'll receive an answer in writing. If the court cannot answer your question, you'll be advised accordingly. You may not request a transcript or a summary of any witness's testimony. You must rely on your collective memory as to what each witness testified to during the trial. Now, you're going to have with you in the jury room the following verdict forms. We have 4 separate counts, so we have 4 separate sets of verdict forms. There are, as to each count, they're basically identical except for count 4, which I'll get to in a moment. And they have the case caption, the case number, for each count, what the charge is and what the applicable revised code is. And the only difference is, and don't read anything into the order in which I read these, one reads, we, the jury in this case, find the defendant, Cindy M. Letman, not guilty of the offense charged in the complaint. And on the other form, it says, we, the jury in this case, find the defendant, Cindy M. Letman, guilty of the offense charged in the complaint. Now, as I said, and as I instructed you, if you enter a guilty verdict, or if you return a guilty verdict on the charge of disorderly conduct, you must continue to deliberate to determine whether or not she ceased to engage in her behavior after a reasonable request to do so. There's a second page to the guilty verdict on that charge, which would reflect your additional finding. It has the option of either saying we find that she did or she did not, and that would need to be signed by all 8 jurors in the foreperson again. When you've reached a verdict on a charge, you'll complete the form that corresponds to that charge and to your decision and sign the verdict form in ink. The foreperson will sign the appropriate verdict forms twice, once in the capacity of the foreperson in the space indicated, and once as a juror on one of the 8 lines provided. The foreperson only gets 1 vote, but just as the same as the other jurors, but must reflect his or her specialized status by virtue of the second signature on the foreperson's line. The court's going to place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these items and return them to the courtroom at the conclusion of your deliberations, and place all verdict forms, both the ones that you sign and the ones that you do not sign, back in the envelope. The court, until your verdict is announced in open court, you're not to disclose to anyone the status of your deliberations or the nature of your verdicts. At this time, I'm going to ask the attorneys to approach and inspect the verdict forms. All right. Does counsel have any objections or additions to the jury instructions or the verdict forms, Mr. King?
No.
Mr. Bodike? And I have these separated, so each of the charges and the verdict forms corresponding to those charges are paper-clipped together. Ms. Murphy, you were selected to serve as the alternate juror in the event of any misfortune or illness to a member of our panel. It's not necessary. It's not going to be necessary for you to serve further. You're not to discuss this case or tell anyone how you would have voted until after the jury has returned its verdicts. You'll be excused shortly, and if you have any belongings still in the jury room, you can retrieve those at the conclusion of these instructions. You are free to remain and await the verdicts if you wish, or you can leave. But please remain in the courtroom until I've had an opportunity to speak with you after the jury begins its deliberations. Now, for the remaining members of the panel, after you retire to the jury room and whenever all 8, and I repeat, all 8 jurors agree unanimously on the verdicts, you'll sign the appropriate verdict forms in ink, place all the verdict forms back in the middle envelope or folder, and advise the bailiff by ringing the bell, at which time you'll be returned to the courtroom. So at this time, Ms. Kyle, will you please escort the jury to the jury room?
All rise.
Be seated. The record should reflect that the jury is now back in the courtroom. My understanding is that juror number 7, you were elected as foreperson?
Yes.
And has the jury reached unanimous verdicts on all 4 counts?
Yes.
Please provide the envelope to the bailiff. Okay. In the case of the State of Ohio versus Cindy M. Letman, case number 25 CRB 00937 on count 1, criminal damaging violation of 290906A1, The verdict reads as follows. We, the jury in this case, find the defendant, Cindy M. Lutman, not guilty of the offense charged in the complaint. It appears to be signed by all 8 jurors in the foreperson. On count 2, criminal mischief, in violation of 2909.07A1, the verdict form reads as follows. We, the jury in this case, find the defendant, Cindy M. Lutman, not guilty of the offense charged in the complaint. Count 3, menacing, in violation of revised code section 2903.22A1. The verdict form reads as follows. We, the jury in this case, find the defendant, Cindy M. Lutman, not guilty of the offense charged in the complaint. And finally, on count 4, disorderly conduct in violation of 2917.11A1. The verdict form reads as follows. We, the jury in this case, find the defendant, Cindy M. Lutman, not guilty of the offense charged in the complaint. All the verdict forms appear to be signed by all 8 jurors in the foreperson. Again, Mr. King, did the state wish to pull the juror?
No, thank you.
All right, very well. At this time, the defendant is discharged. I'm going to have the jury go back into the jury room. I'll be in momentarily just to speak with you briefly, and then we'll have you on your way. So at this time, we stand in recess.
All rise.
This case didn't turn on who was louder. It turned on what could be proven. 2 stories entered the room, but doubt walked out with a verdict. In court, emotions don't convict, evidence does.